Attend the court, please. The Honorable Supreme Court of the State of New Mexico.
Please be seated. Good morning. This is S-1-SC-39152 Avangrid Co. versus New Mexico Public Regulation Commission. Can I have entries of appearance, please?
Tom Bird and Brian Haverly for Avangrid Inc., Avangrid Networks Inc., New Mexico Green Holdings Inc., and Eatonville.
Thank you.
Stacy Goodwin, Associate General Counsel for PNN Resources and Public Service Company of New Mexico. And with me is Patrick Abadaka, General Counsel.
Thank you.
Good morning, Erin Coe, for the Public Regulation Commission, and with me is Scott Cameron, our General Counsel.
Good morning, Justice Bacon and Justices Marian Lanassi with New Energy Economy.
Thank you. Mr. Byrd, it appears that you have 25 minutes for your argument in chief and 5 minutes for rebuttal. Is that correct? Right. And the PRC and the intervener have split their time 15 minutes apiece. Is that correct? All right, Mr. Byrd, you can proceed.
Good morning, Your Honors. May it please the court. The overarching point of our appeal, the unifying principle supporting reversal, is that the Commission's rejection of the merger was not a reasonable or lawful exercise of its authority. The decision we are challenging resulted from too many rule violations, rested on too much incompetent evidence, and reflected too many departures from Commission's the Commission's existing standards to permit this ruling to stand. These overlapping defects were evident in the Commission's disregard for the presumption of innocence in its handling of the evidence concerning the investigation in Spain, the violation of its own rules in admitting hearsay testimony from an expert, Scott Hempling, from Seth Berry, and the Liberty audit.
Isn't it clear that the rules applying to the administrative proceeding allow for admission of hearsay evidence?
That's true, Your Honor, but here we have a rule that expressly prohibits the admission of evidence in circumstances when there is no witness present to sponsor the testimony, and that witness is therefore not subject to cross-examination. So the structure reflected in the Commission's rules is that generally hearsay is permissible, but there are rules that prohibit specific instances of hearsay. In Seth Berry's testimony, Mr. Hempling's testimony, and the Liberty audit are all violations of that specific prohibition against the admission of hearsay evidence where a witness is not present to sponsor it, and therefore it is not subject to cross-examination.
Are you asking us to deliver a rule by way of opinion in this case that any consideration of hearsay evidence would then trump, so to speak, any other evidence, making it almost like a strict liability application of hearsay?
No, Your Honor. As a matter of fact, there are New Mexico cases that say exactly the opposite. And the one I'm thinking of specifically is Chorty versus Jernigan, which predated the Young opinion, but stated a version of the legal residual rule, something very close to what the Young court adopted. And that case specifically says that the admission of hearsay testimony is not necessarily fatal. And the legal residuum rule says that the agency's decision has to rest on some admissible evidence, but that the incompetent evidence, and by the way, when I say incompetent in this argument, I'm talking about evidence that a court of law would not admit in a jury proceeding.
But if I can find in the 41,000 pages of record here, other corroborating evidence for the Commission's decision, doesn't that end the inquiry under the legal residuum rule?
It's a little more complicated than that, Your Honor. And here's a good place for me to emphasize what we're talking about when we're talking about whole record substantial evidence review and the legal residuum rule. The Commission decided that the evidence reflecting a risk of deterioration to customer service outweighed the benefits. So you can't stop at just determining whether there's any evidence of risk. There has to be enough admissible, competent, as I'm using the term, evidence indicating risk that it indicates that the decision that the risk outweighs the benefits was reasonable.
What is particularly unreliable or within the bounds of hearsay of the Maine Public Utility Commission report? That is a report by a governmental agency. In a trial court, that's likely admissible.
I disagree, Your Honor. It was prepared by a consulting agency called Liberty Audit. It was commissioned by the Maine Public Utility Commission, but the commission itself did not prepare that report. It didn't adopt it, it didn't ratify it. It prepared it and it put it in its file. So we have a bunch of federal cases cited in our briefs.
They put it in its file, which is part of their record.
Nonetheless,
They admitted it as part of their record.
That's true, Your Honor, but it wasn't prepared by the commission itself. It was prepared by a private consulting. And this is an issue that comes up under federal law frequently. And the courts say that unless the agency is directly involved in essentially supervising the preparation of the report, or that the private entity preparing the report is itself essentially equivalent to a government agency and applying standards that are like those of an agency, then it's not reliable. Exactly the point you're talking about, Justice Thompson, which is that when you have a report prepared by an outside consultant, it's not the same thing as a report prepared by the agency. The whole logic of the public records or public report exceptions are that agencies typically do their jobs in a way that makes the report reliable. That is not an inference or an indicia of reliability that can apply when the report is privately prepared.
The reliability is that it's an official record, It's findings and conclusions by a governmental entity. That's what makes it.
But it isn't, Your Honor. There was no adoption of the report by the Maine Public Utility Commission. They paid for it, they commissioned it, they put it in their file. There's no indication that any action was ever taken on it. The record is unclear about how that proceeding concluded. It wasn't over by the time the merger case was finished. So it's another example of our opponents relying on a process that is essentially inchoate, that hasn't arrived at a conclusion yet. And so we don't really know what the Maine Public Utility
So
Commission.
let me ask you, do you think there's numerous penalties that were imposed against Avangrid throughout the record? Would you agree that those are, to use your term, competent evidence?
That is evidence that we did not oppose submission on the grounds of hearsay. But under the whole record substantial evidence standard, you have to look at other parts of the record that significantly detract from the weight of that evidence. For example, those penalties were imposed by regulatory regimes that differ dramatically from ours, where the use of positive and negative revenue adjustments is very common. We don't have that in New Mexico. The other thing to remember is that if you look at the May 18th response to the hearing examiner's May 11th order directing basically a cataloging of those penalties and audits, you'll see that there are $20.5 million in positive revenue adjustments that occurred in the same time. So the amount of the negative revenue adjustments has to be offset by the positive revenue adjustments. That's about a third, I would say. The other thing is that the commission's reliance on that evidence didn't account for the safeguards in the modified stipulation to prevent deterioration of customer service. Those safeguards included performance guarantees, penalties, structural limitations to promote proper governance, to prevent improper affiliate influence on the operation of PNM. In other words, the commission, under the whole record substantial evidence standard, has to have accounted for those things, and it did not. It appeared to have concluded.
How do you know that?
Right.
Because they talked about the modified stipulation, they mentioned it, but they never undertook a substantive analysis of its contents.
How do you know that?
Because they're required to tell us so if they did so. And to me, it looks like, and I agree, this is my perception, that they stopped with the conclusion that these applicants are untrustworthy, that there's a criminal proceeding that indicates they're crooks, that they didn't include in their initial application for the merger a disclosure of the penalties.
But if our job is whole record review, so we're looking at everything in the record, and I can parse out many things, some things that kind of would be in your column, favorable benefits to the public, although very limited in duration of time. Credits to customers for 3 years. And if you break down those credits, it ends up being like 41 cents a person. Not huge numbers by any measure. And I then can do a whole record review and look at the negative. What lens am I supposed to view that through if I'm conducting a whole record review? And where does deference lie in that to fact finding?
The answer to what lens you would apply is, I think the law is pretty clear. It's a lens of reasonableness. Was this a decision reasonable in light of the record?
What deference do I give to the commission's fact finding?
Well, Your Honor, that brings me to the point I intended to begin with, to emphasize at the beginning, which is the commission's failure to accord the applicants a presumption of innocence and its reliance on the fact that there was a criminal investigation going on in Spain involving some of Iberdrola's executive as essentially equivalent.
But what about like the testimony that was presented that was essentially, New Mexico, we'll give you a little bit, but this is really to create an anchor for Avangrid to spread its wings throughout the West. And this is really about Avangrid, and it's not about the people of New Mexico. And testimony like that, can't the commission rely on that kind of testimony and have some skepticism about your client's intentions in New Mexico when compared to the monetary pieces of this, which again are very limited in time and per customer, very, very small.
I'll remind Your Honor that the applicants hired an expert to compare the benefits conferred in this case, that the rate credits specifically, and found that they were substantially higher than the rate credits involved in any prior merger, all of which had been approved.
But that doesn't tell me how to balance the additional testimony that's in the record. No question that it's credible evidence because it's an admission of a part of your own client about what Avangrid's purpose was in coming to New Mexico, which is to create an anchor hold for its future growth. And that was really the focus. And can't the commission reasonably give weight to that kind of testimony?
Your Honor, it would be a departure from existing standards. No such examination of subjective purposes for pursuing the merger has ever applied in an analysis of any merger considered by the commission in any prior case. We put that consideration, the beachhead thought, in
That's the word I was struggling for.
the beachhead thought belongs in the envelope containing several other commission departures from existing standards. It's another instance in which the commission imposed standards that we had never seen before in any merger case. Another one, and the one that I find particularly egregious, is the conclusion that the applicants were less than forthcoming, I believe is the phrase, in failing to disclose the penalties of affiliates operating in the northeastern part of the United States in the initial application for the merger. There's no rule, no precedent, no principle that required the disclosure of that information. We have repeatedly made that point. We made that point when Mr. Schanhauer insisted that in our response, we identify the person who was responsible for the decision not to tell the commission about those penalties. And our response was, there isn't such a person because the standards imposed by the affiliate rules say nothing about that kind of information being contained in the initial application.
In the initial application, I was a little confused whether that information was subsequently requested but not provided.
It was requested, it was provided. It was the basis for discovery sanctions because NEE believed that it had not been entirely, had not been completely or fully disclosed. We disagree with that conclusion. The May 18th response itself, it contains a catalog of all the significant negative revenue adjustments and audits imposed. And we took the responsibility of telling the regulators and our opponents what they needed to know quite seriously. And that sort of brings us to the discovery question, which I think is an instance of, and I believe you'll see in the record, there's no evidence to demonstrate willfulness, no violation of a motion to compel, no violation of a commission order requiring the disclosure of this information.
But no evidence that P&M failed to disclose anything. P&M was sanctioned.
Well, actually, that was part of the problem. P&M was sanctioned, but I think on appeal, the commission has conceded P&M shouldn't have been sanctioned.
So where does that take us in this case?
Well, it's got to go back by that for itself for correction. But the point I wanted to make is that leaving aside the whole record substantial evidence question, the legal residuum rule, which is an enormous undertaking for this court, there are features in this record under New Mexico law which by themselves suffice to send this case back down, to vacate and remand this.
The legal residual rule, you brought it up again. If I understand your argument correct, the bottom line of your argument is that hearsay is no longer admissible, no longer usable for purposes of making a decision in any way, shape, or form, because you're arguing that the only thing that the court can look to is whether or not there is evidence admissible in the court of law to support your decision.
That's not
So that
quite,
guts the issue of hearsay. Is that right?
no, that's not right, Your Honor. I think that's an overstatement of our position.
Okay.
I think that our position recognizes that administrative agencies under New Mexico law are permitted to admit and consider hearsay. The legal residuum rule is an appellate standard that is tied in with the whole record substantial evidence review. And together those things operate as the Tallman case tells us, as a winnowing device. That yes, the agency can look at those things at the agency level. When the case comes up for review on appeal, there's a different set of criteria concerning what is competent evidence. And you probably know this. There's a longstanding debate about whether admissibility in court, which is the yardstick used by the legal residuum rule, is the right yardstick for determining competence, or if, as the federal courts have decided, it should be something slightly more accommodating.
But along the lines of Justice Behill's question, the way I read your brief was on appeal, we need to basically divide the evidence up between hearsay and non-hearsay. Look at the non-hearsay and see if standing alone, it was sufficient to support the commission's order.
Yes, and we see an illustration of exactly that process in New Mexico law. And I'm thinking of the Duke City lumber case on remand to the Court of Appeals. The Court of Appeals decision in that case was written by Judge Bivens, who is also the author of the Tallman opinion, where the description of the process as a winnowing appears. What Judge Bivens did on remand in the Duke City lumber case is he looked at three categories of evidence. There was expert testimony, there was testimony from citizens about the health effects of the wigwam incinerator, and Justice Bivens said a court wouldn't admit that evidence. It wasn't sworn. There was no cross-examination of it. It's out. So he based his decision on the evidence that remained after that process.
Doesn't that belie the title of the very rule? Residuum suggests a small amount, a trace amount, not overwhelming evidence to the contrary, or that it seems to me that what you're arguing is that the residuum doesn't counteract or countermand the hearsay.
The word residuum.
It's hearsay plus a residuum. That's the residuum rule.
The word residuum is a fancy way to say residue, which is a word that signifies.
Which is minimal.
Which signifies what's left over after a process, or it's often connected with.
Or that in some way supports the decision.
Well, if there's any left that does, and again, I want to emphasize that the finding that we're examining here, that we're considering whether the record contains sufficient competent evidence to support, is that the risks of service deterioration outweighed the benefits. So the inquiry doesn't end with the court concluding that there is admissible evidence of risk. The inquiry requires the court to then go on and collect the information that withstands this winnowing process and decide whether that residuum, that legal residuum, that part of the record reflecting competent evidence that would be admissible in a court is sufficient to support the agency's conclusion.
And ignore the hearsay, which likewise supports.
The hearsay is excluded, is winnowed out in much the same way Judge Bivens' analysis on remand in the in the Duke City lumber case reflected the winnowing process he later described in the.
That would completely, if we apply the standard you're asking us to, which is to separate out all of the hearsay testimony, that completely undermines the rule allowing hearsay in administrative proceedings. Why even bother allowing it at all at that level if on appeal we're gonna say, we're gonna throw all of that out and we're gonna look at only what would be admissible in a jury trial or a non-administrative court of law. And so I'm wondering how that does not undermine the rule allowing hearsay. How do I even wrap my mind around those two concepts? Because we know hearsay is admissible. Now you're asking us to completely disregard it in our whole record review.
The legal residuum rule, as part of the whole record substantial evidence standard, reflects a compromise between the idea that administrative agencies should have flexibility, they should be able to move quickly and efficiently, they shouldn't be constricted by the formality and difficulty of operating under.
I disagree with you. I mean, case after case talks about the legal residuum rule as prohibiting reliance solely on uncorroborated evidence, not eliminating uncorroborated. You're asking us to completely eliminate any hearsay testimony in our review, and that is not what the legal residuum rule is based on. A finding of fact cannot be based solely on hearsay evidence, but must be supported by a residuum of legal evidence. That doesn't say disregard the hearsay. Otherwise, we wouldn't have a residuum rule. We would just be applying the rules of evidence on appeal and saying, well, it was hearsay. We're going to pretend it didn't exist. And we're going to look and we're going to reevaluate everything in the record. As opposed to, yes, there was hearsay, but now there's also this residuum of evidence and testimony that is fully admissible, competent, to use your words, that then supports the finding.
Justice Bacon, I would ask you to look at the Tallman case and the Duke City Lumber case.
I'm looking at Young, right out of the gate, Young. Evidence that is competent under the exclusionary rules is necessary to support an administrative finding. The revocation of the license in that case could not be based solely upon hearsay, solely. It's not directing us to exclude that testimony. And then if you look at the administrative law treatise, case law from many, many different jurisdictions, it's hearsay plus a residuum, not exclude the hearsay, only look for anything else that's in the record. So I think you're putting a spin on the legal residuum rule to advocate before this court that we exclude all hearsay evidence. You've said that several times. And then we hunt through the record looking for that which would support the commission's finding, as opposed to hearsay plus some modicum of competent evidence.
Again, Your Honor, I would rely on the Duke City Lumber case on remand and the Tallman case, where I think the notion of winnowing and separating out, excluding on appeal, the hearsay evidence is reflected in the process as you see it in those cases.
Before your time is up and we went down the legal residuum rule, I think I'm sure a lot of questions on that from the other side. Your statement was setting aside, before we started this, I think you said setting aside legal residuum, which I agree is a big set aside. Can you quickly outline, I think you said setting those aside, we believe we have the following grounds for reversal. Just
Thank you, Your
real quick,
Honor.
you have a
I'm
minute
glad you
45.
remembered the long ago detour, but it's in our view sufficient for setting this, vacating and remanding this case, that the commission disregarded the presumption of innocence concerning the investigation in Spain. The commission equated an ongoing investigation, one that had not reached any conclusion about guilt or innocence, an inchoate investigation under Spanish law. The commission equated that proceeding with a determination of guilt. They decided that that evidence reflected that Iberdrola's executives and Iberdrola were perpetuating a criminal culture. Commissioner Hall specifically said,
Is there anything in the actual written order that reflects that statement that you just made regarding the finding of guilt?
I was about to read to you a statement that Commissioner Hall made in the Open Meeting Act on December 8th. It's at one's supplemental record proper 303 to 304. She said that the investigation proved, quote, just plain illegal behavior, bribery and surveilling, spying on people who oppose their objectives. Two other commissioners specifically identified the investigation in Spain as support for their vote to turn down the merger. Our reply brief cites 8 cases, including 2 from New Mexico, illustrating the point that the presumption of innocence is applicable in administrative and civil proceedings. The best of those cases for our purposes is the Steinhaus case, in which the court rejected on appeal the admission of an indictment against the party in the case. I see my time is up.
Thank you. Ms. Lecoq.
Good morning, and may it please the court. This case is really about the process by which the commission undertook its duty to weigh the benefits and harms of this potential merger. And the commission followed its process with respect to this application. It weighed the benefits and harms, it made a determination that the proposed transaction was not in the public interest, and it denied it. And this decision by the commission should be affirmed for 3 reasons. First, the decision was not arbitrary and capricious because the commission weighed, again, the potential benefits and harms. Second, it was based on substantial evidence in that it complied with the legal residuum rule. It relied on proper evidence, and it was not internally inconsistent. And finally, the commission did not abuse its discretion in imposing discovery sanctions because the commission issued a discovery order that was not followed, and the commission is permitted to take appropriate actions.
Who was sanctioned in that discovery order?
The discovery order sanctioned Avangrid.
Only?
Yes. Yes.
E&M was not mentioned in that order?
Correct. Correct. The commission has a duty to ensure that the proposed transaction is in the public interest. And the commission's test for whether the public interest is served by this proposed transaction is determined by the facts and circumstances of each case. So we don't look at prior mergers. We don't look at what was done in a different case because the facts and circumstances of this particular case are what the commission is looking at. And it should require a positive benefit to ratepayers if the merger is to be approved. In determining whether it's part of the public, whether the public interest is served, the commission is allowed to look at both quantifiable and unquantifiable benefits. And there's a 6-factor test, essentially, that the commission looks at. And really, it's the last 2 factors that are mostly at issue here, which is careful verification of the qualifications and financial health of the new owner and adequate protections against harm to customers. So here, the commission weighed the ample amount of evidence that is in this record.
It has to be competent evidence. Let's get towards this. Let's have a conversation about these audits because they're significant, right? I mean, I understand the weight they may be given. It has to be competent. I'm not quite convinced this is admissible evidence. So I need you to tell me in the first instance how these audits were used by New York, Maine. Were they commissioned, not incorporated in the record, not part of the findings? The exclusion is, it should be a fact finding, quite frankly, by that governmental entity for it to be reliable. Can you clarify that for us, how it was used?
Yes.
Are you arguing it's not hearsay or that the commission is okay under the residual?
Okay, Justice Thompson, let me back up just a little bit and say that the commission is permitted to admit all relevant evidence. So really, any evidence, right, that is relevant to those in particular, those 2 factors. So when looking at the Liberty audit, whether it is was proper to take administrative notice of or not, it is still relevant to these 2 factors. So looking at that, it is admissible. Now, whether it's hearsay or not would be kind of the question that we've been talking about.
It also has to be reliable. I mean, there's always that overarching, so relevant and reliable, but that's the only 2 requirements for the commission to admit it.
That's correct. And it was reliable because it was, first of all, commissioned by the Maine Public Utility Commission. It was uploaded on their website. It was the final report that was uploaded for the public to see. In that sense, they adopted it and said, we're being very transparent. If the Maine Public Utility Commission relied on it in that way, then it stands to reason that the New Mexico Public Regulation Commission could rely on it in that way. Whether it was proper to give it administrative notice or not goes to the question of whether it's a government report. And as you stated earlier, Justice Thompson, the fact that the Maine Public Utility Commission commissioned this report by a third-party entity does not mean that it is not a government report. Because it was adopted, because it was uploaded onto their website, that renders it a government report, which then would be proper to give it administrative notice and then would not make it hearsay.
In the record, is there any connection between the audit and any action taken by those regulatory entities? Civil penalties, things like that?
In Maine?
In any of, sure, Maine used Liberty, but you had, it seemed to be audits from other states.
I don't know, and I don't know that that's necessarily relevant, because really what they're looking at is how the, how Avangrid was functioning in Maine in that report, and then using that to determine, basically, is this going to lead to potential harms here in New Mexico? And that's what it's used for, in determining that sixth factor. Is this a kind of a sign of things to come here in New Mexico? And the commission determined that it was. If we want to go back and talk a little bit about the legal residuum rule, the statements that your honors were making are absolutely correct. This is an important rule to have in administrative proceedings, because in these administrative proceedings, the administrative body often, probably most often, has specialized knowledge that it uses in order to conduct its regulatory business. It has the ability, and this court has given it the ability, to look at the evidence that it has in front of it, determine whether it's reliable, whether it is relevant to whatever it's looking at, and admit it. And using its specialized knowledge, it is permitted then to make a determination as to whether, to weigh the reliability. And so admission of hearsay evidence is extremely important in administrative proceedings, and particularly in this one.
Counsel, what about the claim that there was no sponsoring witness and no opportunity to cross-examine? How do we deal with that when we're talking about hearsay?
So the rule is that all relevant evidence is admissible, which in the opinion of the presiding officer is the best evidence most reasonably attainable, having due regard to its necessity, competence, availability, and trustworthiness. So the commission, when all of these reports were rebutted, so whether it was admitted during the actual hearing, whether it was adopted during the actual hearing, does not actually go into whether or not it is, first of all, relevant, and whether the commission can consider it, because it was rebutted.
So Avangrid and PNM had the opportunity to put on a witness to say, no, this is not the case.
That's correct.
Okay.
Can I go back to this discovery thing, because it's kind of bugging me? In your answer brief, it stated at the top of page 60, the commission, however, agrees with PNM that the commission's decision to go beyond the recommendations to extend liability for the sanctions to the other appellants was overbroad. What other appellants are you referring to?
The recommended decision, the certification of stipulation, recommended that the discovery sanction only be applied to Avangrid, because it was Avangrid that the commission or the hearing examiner determined was at fault for not following this discovery order. The final order from the commission lumps both PNM and Avangrid together into the joint appellants.
So the final order did include PNM?
Yes, it did.
Okay.
And what do we do with that?
Well, the rationale for that was that.
I don't care about the rationale. You've conceded that that was improper. What does that do procedurally to this case?
I don't think it does anything procedurally.
Why?
If it's only the discovery sanction that we're looking at, the rest of the case, the commission's decision should be affirmed, because it doesn't have anything to do with the remainder of the decision.
But we have to remand the entirety if we find an error.
Well, first of all, Avangrid paid the entire fine, so there wasn't really any prejudice.
But there's a
to
finding
PNM.
against PNM, so that is problematic. But do you agree we'd have to vacate the entire order and send it back?
No. Even though the certificate of stipulation and the final order has the certificate of stipulation has PNM and the final order, Avangrid, and the final order has PNM and Avangrid. They really worked together. They worked in conjunction. So
you're adopting New Energy Economy's argument, which is basically that they were working jointly. They jointly signed the pleadings and correspondence related to discovery, and that's where you want us to hang our hat.
I don't think that it is a fatal error such that the entire case needs to be remanded. I think because there is ample evidence that everything.
But if we
is joined.
disagree with you, we would have to remand the entire thing under the current status of the law.
Yes.
Is there any evidence that PNM knew about the things that were not disclosed that later came out, the criminal investigations? Is there any evidence that PNM knew anything about those things? If we're gonna hold them to, you signed the pleadings too, it seems as though there should be some sort of culpability or knowledge on their part.
I think the fact that they worked in conjunction through the entire case is demonstrative of the fact that, because they work so closely together, that it's very possible, yes, that they knew about the.
Possible, but there's no evidence that they actually did.
I don't know for sure whether there is evidence. But again, I think that it's very possible to come to that conclusion.
So
when-
how would they have, but they weren't able to produce those documents. Those documents presumably were not in their possession to produce or review or determine whether they should object on confidentiality.
Many of the documents were publicly available, such as the SEC filings. So some of them were available to them.
But if they're publicly available, what are we fighting about?
Well, and then, so that, it's really the fact that it looks like it was being hidden from the commission, even if it was publicly available, just to did the commission know, or did the hearing examiner know to go look for them? And in this case, the hearing examiner did find it, and then.
And that's one of the complaints here of the appellants, is that the hearing officer did their own research.
Yes, which is permitted. The hearing examiner is permitted to do its own research. The commission
Counsel,
is
I
permitted.
have a question. If we should reverse, send the case back based upon the discovery sanction, what's the status of the case on remand to the commission? What does the commission do with the case at that point?
The commission would review, depending on what the order says, the commission would review whatever is placed in front of it, whether it is we need.
It's reversed based on the discovery sanction being overbroad, period. What happens to the case on remand?
I imagine the commission would have to take another look, whether it's at the old application, whether it's the old stipulation, whether it's a modified stipulation. I'm not entirely sure, but I know that the commission would review it again, because that's their obligation.
The entire case.
Yes.
Do they have to review the entire case at that point?
Well, again, I think if it is
Certainly that would be your opposing counsel's position, that the whole thing is open again.
I think it depends, again, on how the order is written.
It says exactly what I said.
Yeah.
So please answer the question.
If it goes to just the discovery, then I would say that the commission would be able to look at just the discovery sanction and hold, the decision and the weighing and the benefits that it did in the original.
But they're not obligated to, is that right?
I don't believe so.
Thank you.
I have concerns about if you could address quickly with your time left, the use of the Spanish investigation. As certainly not versed in international law. Spanish process is a little different. Magistrates almost kind of initiate these prosecutions. Can you address any concerns about the use of the finding of the opening of the criminal investigation and the weight the commission gave to that in making its decision?
I don't think that the commission preemptively judged the outcome of this case, but I do think that the commission made a determination that if there's sufficient evidence to warrant a criminal investigation, that should be cause for concern for New Mexico. And I think that that's the extent that the commission took this Spanish investigation. I think it was concerning, but again, when compiled with the rest of the massive amount of evidence. It just goes to that sixth factor. What are the potential harms that this merger could cause New Mexico? And the commission followed its process. It weighed those factors. It used this concern that it had to, as another way, another thing to weigh when it was weighing them.
Supposing
Came to its
a
decision.
criminal investigation was initiated by a corrupt dictatorship.
Well, I don't think that's the case here in Spain.
Well, suppose that it was. Are they not entitled to the presumption of innocence in both cases?
Well, and that's the thing, is that I don't think that they're foregoing the presumption of innocence. All that they looked at was the possibility that this could be a concern.
Thank you.
Thank you.
Ms. Manassi.
Good morning, Chief Justice Bacon and Justices. May it please the court. My name is Mariel Manassi, and along with my co-counsel, John Boyd, who's out of the country, we represent New Energy Economy and the many thousands of New Mexican members. Before I go into my prepared remarks, I would like to address some of the questions that you asked. So I believe Justice Thompson asked a question, as a result of the Liberty Report, was Avangrid CMP, which stands for Central Maine Power, penalized? And the answer is yes. And that they were penalized $9.9 million. And that is in the record. And it was the largest fine that Maine had ever meted out in Maine history. And that still stands. Justice Vargas, you asked a question about was there an ability to cross-examine on the Liberty Report? I just want to say that this was completely adopted by Maine, but more importantly, it was introduced into evidence by Avangrid. So that's extraordinarily important for you to know. And
In
that is
Maine or here?
here. And that was at 36 RP 6745. And what's so important about that is not only will you see when they put the Liberty Report into evidence, but they also put in their response to the Liberty Report, including their lawyer's testimony and their press release. So it's to see it there. And what did they say? They said, this was a good report. Thank you so much. We appreciate this report. It shows that we're improving in Maine. It also said we endorse and tout its veracity and reliability and competence, because it took them a year to produce the report, and they did a comprehensive investigation looking at all sorts of lots of meters and all sorts of documents, and interviewed CMP and Avangrid witnesses. So there in Maine, they touted the report, and then they put that evidence into the record here. And so the fact is frankly, they've waived this argument. Your rules say, and you'll notice in the brief of Avangrid, they did not cite to where they objected. They later on, months later, objected. And I need to read to you when they did finally object many months later, this is what the hearing examiner said about that what he called untimely objection. And I refer you to 65 RP 22403. And this is a quote from the hearing examiner from that order. The audit report is evidence that is relevant to the issue of how the adequacy of P&M service might deteriorate under the Iberdrola Avangrid group of companies. The commission's interest in the findings of the audit report was noticed to the joint applicants as early as May 11th, 2021, which, by the way, I'm interrupting my own self, they didn't object to that either. And I'll get to that in a minute. The joint applicants provided the audit report to the commission as directed by the hearing examiner, but without objection at the time. And the parties have relied upon the audit report's findings in their July 16 pre-file testimony. It is fairly late for the joint applicants to assert their objections. And I'll just tell you for the record, it was not only New Energy Economy, it was PRC staff, it was New Mexico area that relied on that report in their testimony. I'd also like to point you to something else that's very important. And this is what Avangrid stated under oath. Avangrid commits to provide the commission with any information the commission requests related to Avangrid's other utilities. That's at 36 RP 6745. Avangrid acknowledged that in 19-00234 UT, another merger proceeding, the hearing examiner there issued a bench request for information about any regulatory investigations involving affiliated utilities. So not only is there precedent for this in the PRC, but Avangrid acknowledged that. And they said transparency is a cornerstone of Avangrid's governance and sustainability systems. And that is continuing on with that 36 RP 6752. And I'm sorry, but I don't remember which justice asked this question, but you said, well, oh, this was actually, I do remember, it was you, Justice Vihel, I think, and Justice Vargas, when you were questioning, well, should PNM be responsible for the sanctions as well? And yes, first of all, they signed every single filing that I didn't look back at everyone, but as far as I can remember, every single filing in this case came from joint applicants. And that's how they were referred to.
But who was the discovery directed to, and who was capable of responding to it?
Thank you, Justice Zamora. It is true that the focus was on Avangrid during the sanctions, the initial sanctions. But if you look at where I pointed you to when they were questioned specifically by the hearing examiner, they asked Public Service Company of New Mexico, why did you allow this to go on without, that you weren't forthcoming and that you didn't provide this information to the commission? And their answer was, well, we saw it, we knew about it, but we made a judgment call and we didn't think it was out of line. And what they said was, we knew about that there was revenue adjustments in Maine and Connecticut and New York for reliability issues and for this huge billing debacle in Maine, et cetera, but and for storm-related failures. But on balance, we made the judgment that this was just in line with the normal activities of the utilities there. So they knew about it and they made the judgment. So
And where in the record is that what
is
you're
at-
referring to now?
I don't have the exact page, but it is at their response, their May 18th response. Both Avangrid and PNM responded, and it is within a page or two of 36 RP 6745. I even know who responded at PNM from it, and it was Don Terry's response, because that was a question by the hearing examiner to say, Avangrid, why didn't you provide this information? And then also PNM, why didn't you provide this information, excuse me. And so it was their judgment. They made a judgment call here. So should they be responsible? And I think the question also that you asked, Judge Vigil, is should we send this back? This is a case of enormous magnitude that will affect New Mexicans for decades. And should you look at this decision, which was a mistake by the commission to not delineate and continue to hold Avangrid accountable specifically. And instead, the commission made a mistake and said joint applicants, as they themselves referred to them themselves throughout the entire case. I would submit to you that it's harmless error. Why? Because first of all, Avangrid is the only party who paid the sanctions. So that's so. And should PNM be responsible? They applied jointly. They knew what was happening in this situation. And they were communicating throughout, as you could see from some of the, sites that we proffered in our brief. They jointly filed every single document that I am aware of in this case. And so should they both be held responsible, like joint and several liability? I believe so. There was no harm to PNM. And I just want to ask you, is all of a sudden now PNM, who's seeking to merge with Avangrid, saying, oh, we don't want to be tainted by the
So let me ask
discovery
you,
violations?
if I disagree or we disagree that the sanctions against PNM were appropriate, how can we not send it back under the current statute as written? I mean, it limits us a lot.
It does. I understand that. And thank you for that question. I think that if your honors decided that the decision was correct, and that you state that you uphold the commission's decision, but for the sanctions that were also included against PNM, and only that, and ask, as your normal orders say, that you want this is remanded pursuant just to the instructions made by this court, then yes, they could uphold the decision and reissue
How
an
do we
order.
do that, though, in light of the language on 6211.5 that says, if there's any order that's unreasonable and unlawful, the only thing we can do, the Supreme Court shall have no power to modify the action or order appealed from, but shall either affirm or annul and vacate. We get to do one or the other. How do we parse that?
Well, what I can tell you is that in the past, when this court has upheld prior orders, but had problem with only one aspect of the order, and it's come back before the commission, then it has reaffirmed its prior order with adjustment, and that's it. And I can give you an example of that. It was in the PNM versus PRC case for P3D. I think it's 360.
That's PNM act, I mean, but that's PRC acting on its own.
Correct.
I think Justice Vargas' question is, we can't direct them to do that or anything else.
We can certainly say what we think about the claims that have been brought to us, but our decision about what we think about those claims, we can only affirm or annul and vacate. So the PRC can decide, we want to hear this all over again, correct?
They could, but they wouldn't. That's just the practical reality of it. That's not what they have done.
I'm not sure that that's true. We have a completely different PRC
We
structure
do.
that is quite the mystery to this court at this time because it's all new.
Yes, I understand that.
I'd like you to address I am troubled by this Spanish investigation, and the commission stood up, and we're not gonna see them again, so you're gonna have to defend them a little bit here. They said, well, look, the hearing officer said this may be of interest to you. That's different from what is quoted in the record from what the commissioner said. The quote in the brief is from Hall, just plain illegal behavior, bribery and surveillance, spying on members of the public. Commissioner Maestas, Commissioner Vicente Aguilar cited the sealed investigation suggested should be made public. You can either attack it from qualification or competency of that evidence. How is that at all perhaps relevant, but probative? And what is the reliability of at that stage in the proceeding where they were in the Spanish tribunal, that a commissioner could base a decision based on that?
Thank you for that question. I don't think that they based their decision on that. There's no evidence that they based their decision on it. There is evidence that it influenced their decision. And again, like what you all have been.
All right, well, I have Commissioner Hall's, do you disagree with the following language? Quote, just plain illegal behavior. Did Commissioner Hall say that?
I agree that, that Commissioner Hall said that. I heard her say that. There has been plain illegal behavior by Avangrid and Iberdrola in this case. And so, it is consistent with, unfortunately, a pattern of misconduct that has been, that has not only, that has tainted the.
Isn't that akin to like once a crook, always a crook?
Yes and no. First of all, again, they put this information into the record. They did. Avangrid did. So that's number one. Number two is.
Because they were ordered to.
They were ordered to.
It's not like they, oopsie, put this in the record. They were ordered to put this in the record.
Well, not this specific investigation, but the fact is that they were ordered and they didn't object at the time. They said, oh, we value transparency and we have nothing to hide and we are willing to give you everything, is what they said. I'm backing this question. Thank you.
You know how much time left. My concern is specifically this. How do you argue that was not a basis of a finding that they took judicial notice of this initial proceeding in order to reach their conclusion?
I believe under the Gonzalez case that Avangrid has cited that the court, or in this case, the agency, is entitled to take judicial notice of a criminal proceeding as long as they don't presume guilt. And
That's what Commissioner Hall stated. It does sound like a presumption of guilt, although I do agree that it's nowhere in the final order, but that is what she said.
yes, and I do think that it's the Spanish investigation was extraordinarily troubling. There's no question about that to the commissioners for good reason. And they did include the Spanish investigation as a factor in their decision. But was it, like the legal residuum rule, was it the basis? No, it was not the basis. And I believe that there was plenty in both hearing examiner Schinauer's certification of stipulation and even the final order that said the risks don't outweigh the benefits.
Thank you, Ms.
Thank you.
Nancy. Mr. Byrd, 5 minutes.
Thank you, Your Honors. Just a few points. I feel like it's really important to go back and revisit the details related to the main audit. Mr. Schinauer conducted his own independent factual inquiry one weekend before the May 11th hearing. He discovered the existence of the negative revenue adjustments and the audits. At the May 11th, 2021 hearing, he directed the applicants to provide all information relating to penalties and audits for all affiliate utilities. Our clients complied. And then when it came time, when the deadline arrived for objecting to the admission of that evidence into the record, the joint applicants filed a motion to eliminate, a motion to strike, because some of this information had been included in testimony. And Mr. Schinauer concluded that the motion was untimely. Even though it was filed on the deadline, he decided that some parties had already relied on this information in preparing their testimony. He moved the deadline. That is one example of the procedural missteps in this case that make it susceptible, that should compel you to send it back for rehearing, wholly apart from the legal residuum rule.
Did the federal court in, I'm going to mispronounce this, Levesque, in this class action case, rely on those audits in their summary or motion dismiss?
No, Your Honor, and this is another clarification I need to make about the main audit. The main audit concerned the practice supposedly of Avangrid of taking its executives and its resources and moving them around in ways that detracted from the performance of the utility itself. That had nothing to do with the billing rollout, which was the basis for the $9.9 million penalty that Ms. Nanasi mentioned. Those things were unrelated.
So the main court in the class action did not rely on that audit in its order regarding the motion to dismiss, did not find it sufficient to base its ruling for its motion.
I don't think so, Your Honor. I have to concede that there's so much here. I'm not sure I'm recalling the Levesque case properly, but my recollection is that they were unrelated, that there was no action either by the commission or by a court in response to the main audit that concerned the movement of personnel and resources within the Avangrid's structure. And I want to emphasize again that there was a timely objection, a motion to strike, a motion to eliminate, directed at all of the evidence we're complaining about here today, which brings me to another point. If you look at Shorty versus Jernigan, you will see this court, in an opinion written by Justice Bryce, concluding that yes, there may be some substantial evidence here that supports the Liquor Control Division's decision, but the hearing itself was prejudicial to the parties because there was an admission. The agency admitted two kinds of hearsay evidence, one concerning testimony from a reporter, the other petitions from religious groups about how they opposed the presence of liquor businesses in their neighborhood. And the court decided that this was not a fair hearing, that even if there is substantial evidence, and we're not going to decide whether there is or not, this has to be done over because it was unfair. That's the reason we have shifted our focus to the many, many procedural violations this order rested upon. And we catalog them fairly precisely, I think, and fairly completely in our supplemental authority letter in response to this court's decisions in the Q-Link case and the El Paso Electric case, both of which were instances of this court sending the case back because the commission had violated its own rules and departed from existing standards. It's telling to me that we are disagreeing at this point in the proceedings about the discovery order, and that we still have from the commission vacillation about whether the sanction was appropriately imposed on all of the joint applicants or just Avangrid. And that accompanies the other vacillation in relationship to that order, which is whether it reflected willful conduct or whether it was a violation of a commission order or whether it was a violation of the analog to Rule 37. That is indicative, and I hope it tells you how uncareful the commission has been about its own rules, about how uncareful it's been about punishing behavior that it thought was inappropriate, and that I would ask you to consider those repeated misapplications of the agency's own rules, looking at Jordy versus Jernigan to decide that the case should go back down. Rules are the barricades against irrationality and illegality, and they must be upheld by this court.
Thank you. Council, thank you for your arguments today. It was well done by all parties. We appreciate it. The case is deemed submitted to the court as of today, and we'll get you a decision as soon as practicable. Thank you.
Attend the court, please.